This week, we discuss the impact of the new SEC regulations on cybersecurity. In the leadership and communications section, Steve Katz, world's first CISO, dies in hospice care. Top CISO communities to join in 2024. Workplace Culture 101, how to create positivity at work, and more. Business Security Weekly starts now.
This is a Security Weekly production for security professionals by security professionals. Please visit securityweekly.com/subscribe to subscribe to all the shows on our network.
Broadcasting live, it's the show where we explore the business of security to improve the security of business. Your trusted source for actionable insights on leadership, communication, and innovation. Get ready for Business Security Weekly. If your organization is ready to embrace edge computing, we have good news. The 2023 AT&T Cybersecurity Insights Report provides everything you need to know to get started. In the report, we identify the common characteristics of edge computing. We found edge use cases are rapidly coming online, and we reveal how to secure edge computing. Most importantly, you'll learn how to prepare for your edge ecosystem. Get your complimentary copy of the report today by visiting securityweekly.com/ATT Cybersecurity. That's securityweekly.com/ATT Cybersecurity.
Hi, folks. I'm Adrian Sanabria, the host of Enterprise Security Weekly. Every week, we interview the most interesting folks we can find, talking about the most pressing cybersecurity issues and challenges facing the enterprise today. Myself and my co-hosts have each been in the industry for decades, long enough to see the patterns in the industry and explore where trends are going. In addition to enterprise challenges, we also follow the vendor space, the most interesting security startups emerging, technology and product trends, all of the most interesting funding and acquisition announcements. Finally, we love to discuss the latest trends in tech and how they'll impact cybersecurity. If you're wondering how the latest in AI, quantum computing, cloud, and DevOps is going to impact security a few years down the road, you should follow the Enterprise Security Weekly podcast.
Welcome to Business Security Weekly. This is episode number 331, recorded December 11th, 2023. I am your host, Matt Alderman. Joining me for this solo session, we don't have a guest. He unfortunately had to cancel at last minute, but we're still going to cover the topic anyway. So that means Jason and Ben and I get to talk. So first, Mr. Jason Albuquerque, welcome.
Hey, what's going on, Matt? The Patriots actually pulled one out. We had the Thursday night game against the Steelers, and we won 21-18. So we eked one out. But I'll tell you, Cowboys, 49ers, Miami, Ravens, those are some scary bunches of teams right there. And they're going out there and kicking some butt and taking names. I am going to the Kansas City game against the Patriots next weekend, so that'll be a fun time.
Yeah, it's interesting. Like, this weekend of football, so the Patriots win, that puts a dent in Pittsburgh's chances. You've got Kansas City loses to the Bills, right? Yep. The Browns win, Denver wins. Like, it's getting really crowded in the wild card race, and so it's a little crazy right now. Yeah, definitely a fun week to watch for sure. Also joining for this segment, Mr. Ben Carr. Welcome, Ben.
Hey, Matt, Jason, how's it going today? Starting to feel a little like fall here in Texas finally, cooling off, but yeah, doing well. Glad to be here.
Awesome. Join our Discord channel to chat with us throughout the live show today. We already have chats in there right now. Visit securityweekly.com/Discord to receive an invite and become part of our community. All right, so originally we had a guest to talk about this topic, and he unfortunately had a personal item, so I had to cancel last minute. But I still want to cover the topic because this week is a big week. The 15th, anybody whose year ends 15th or later is now under the new SEC cybersecurity rules. December 18th has some initial reporting requirements around your risk management program. So this next week is kind of a big week coming up around the SEC stuff. And as I was preparing for the segment, there were three terms came up that I wanted to dig into and debate a little bit: materiality, disclosure, and evidence. And so I'm going to frame the topic around this, because I think it was interesting. I was traveling last week. I was in studio for Paul's show. I was doing some meetings for CyberSane up in Boston. And the first night, Jason, I get there, right? The Bengals game's on, right? Again, talking about these interesting games, right? So game's on. I get to the hotel. I go straight to the bar. And I'm just sitting at the bar, and I'm chatting with two guys next to me. We're talking about football. One's a Philadelphia fan. The other one's, I think, New York Jets. Anyways. And we're talking, and all of a sudden we got on work topics. I don't know how we did it. Come to find out, he's a corporate CFO. And I said, and he's a publicly traded CFO. So I asked him, like, what are you going to do for the new SEC requirements? And we got into this really interesting conversation because he owns the security risks, right? We talk about this on the show all the time. Who owns risk in your environment? Well, at this company, he owns it. As the CFO, all risks roll to him, including cyber risks. And I said, how are you going to do this? And so we got into this really interesting debate. And it starts a little bit with what is considered to be material from a cybersecurity perspective. Can you define materiality?
Yeah, and I mean, I took a quick look at the SEC rules, and it's like anything, it can be vague, right, and challenging. So the SEC cybersecurity rule defines material incident as one that has a substantial likelihood of being important to a reasonable investor. That's the main clause that I pulled out of there, right? Significantly impact the total information available and how it impacts an investor. So for me, that's, I look at it, and that becomes a challenge, because where do you draw that line? How do you draw that line?
Right. So let me give you an example. And Ben, I want you to come in on this. So I used to have a conversation. Just 1 second, Ben. I used to have this conversation with an oil and gas company, and materiality to them was anything over a risk over $1 billion. Now, I would say that $1 billion potential cyber impact would be material, but I don't really think that is how big most of them will be. And so now you have to think about, Jason, in your definition, like, kind of where's that threshold? Is it 100 million, 10 million, 1 million? Like, and it probably depends on the size of the organization you are.
Sure. Yeah. And is it all just revenue based as well, right? I mean, I don't know. Is it all about the money, or is there a section of it that says how is it impacting the customers that could potentially have an adverse effect on revenue? So I don't. It's so vague and such a strange line that we have to tiptoe on, right? So it's going to be difficult. And then around with that comes the tight requirements of disclosure, right? So now you have that challenge of making a decision on your toes really quickly.
Yeah. So, when I think about materiality and how usually it gets interpreted and when we think about it, like, to the point you made, Matt, I don't think it's just a dollar threshold, right? Because I'm assuming what you were referencing was an impact to revenue, right? But that doesn't necessarily mean that it wouldn't be considered material if a reasonable investor would vote depending upon it differently, right? I mean, that's part of it, is how the reasonable investor would vote in a shareholder or stockholder meeting if that material fact, if that fact, as defined as material, became known. Would it change the vote, or would it alter the way that person voted? Or one could also think about it: would it alter the way a person makes their investment decisions? And so, if there's very low impact to revenue, but the end result is corporate governance or confidence is swayed, that then in fact could affect share price in a large extent, that may change the way an investor would decide to make that investment decision, and that would become material. So that's kind of the problem with materiality. And I was talking with the lawyer about this about 2 weeks ago. It's not as easy as saying these are the 5 criteria that materiality becomes an actual thing. It's more a judgment call, right? And so I guess, my position has been you always have to err on the side of caution. If you think it might be material, it probably is material, right? Because otherwise you put yourself in a lot of jeopardy if you vote in a very risky fashion and say, oh, we're not going to consider this material.
And the other piece of it too is words matter in these instances, and they put the term a reasonable investor in there. So what is the definition of a reasonable investor? Right? I look at the words that they put in these clauses, and it specifies a reasonable investor. So what would that definition be?
Definitely not Warren Buffett.
That's Warren Buffett, not the reasonable investor, right? But I don't think necessarily like the three of us either. In a casual investment in a company, it might not alter our decision in it, right? So it's really hard to, like, a lot of these terms, and I think we should all preface this by saying we're not lawyers, right? So we're not giving any legal advice. Which is what I was going to say. The lawyer who I spoke to specifically said, "Hey, I'm not giving you legal advice on this. However, the terms are specifically vague. Like, they're vague for a reason because they want to cover a whole host of things, which, if you're CISO butt in the seat, makes it really hard to figure out, like, man, is this really material or not? And then asking advice of internal counsel, like, they could be, I mean, they have a specific bias, right? So it isn't easy. This is a really challenging thing to figure out what you really consider material is. And again, I vote for being a little bit conservative on what you think. So you kind of covering yourself a little bit, right? A little bit of CYA never hurt.
Yep. So we have
agreed.
So Jason, we have a little precedence on this called Sarbanes-Oxley. And this is where the conversation with that corporate CFO went. He said, the challenge I have is for the financial side. When Sarbanes-Oxley came out, I used the COSO guidelines. We don't have an equivalent of that in cybersecurity. So CFOs are struggling a little bit around this concept of using something like Sarbanes-Oxley materiality rules for cybersecurity, because there were some guidelines there. And so what do you use as the guideline? What is the guardrail? Is it dollars? Is it a % of revenue? Or is it something else? Right. And I think that's one of the really interesting challenges, because it leads into point number 2, as you already said. If I don't know what materiality is, then my disclosure timelines, when do I disclose and not? Because first I have to determine whether it's material or not.
100%. And again, it's a challenge because you only get 4 days, right? So 4 days is a very short time to, number one, determine that, and then the clock starts to tick. And then all of a sudden you have to start getting a whole slew of stakeholders involved, right? So you're starting to have conversations with legal, with your in-house legal, with your IT, with all the executives, with your board, with PR, with the security team. So, I mean, you're getting a whole slew of folks involved now to help you with this, now that you've deemed it material. So that way you can meet the expectations of the regulation. And hey, I mean, I know as a cybersecurity professional, we want to be conservative and we want to, deem it material as soon as we possibly can. But the other side of that coin is you're going to have risk managers like a CFO who says, is it worth pulling the trigger quickly, too soon? And then all of a sudden you start having a brand issue, a stock issue, and you're really lighting it up on a PR side of the aisle before you really needed to. So that's the balance that I think risk managers like a CFO are going to be looking at.
Jason, like there's 2 points in there you brought up, which I wanted to hit on, and so it's great synergy there. So the first one is, so you've got a 4-day reporting window, and you're trying to figure out if it's material, but at the same time you're trying to figure out it's material. You're fighting the fight on, you're in the midst of an incident or a breach, right? Mm-hmm. So now you've taken not only your eye off the ball to fix the problem and solve this, but also a lot of the people who are potentially involved in other areas of the business to also address the breach in trying to fight this fight of, like, how do we do material and how do we report it? And the second point is, like, I think what you just brought up is, so there was a case from 1976, Justice Marshall opined on, and the concern he had is that he noted the importance of the concept of materiality as a filtering mechanism. And what he said was, some information is of such dubious significance that insistence on its disclosure may accomplish more harm than good. And if you think about that, like that's what we're being forced in is, okay, do we report this because it's actually going to cause more harm to stockholders and more harm to the market because we're reporting this and potentially negative results come out than the material issue itself if we define it as such, right? And that's a very concerning thing is the no man's land of we don't have clear-cut guidance on when to call the spade a spade.
Mm-hmm.
Yeah, and there isn't a lot of precedence here, Jason, right? Even the Solarwinds case going through has nothing to do with the new rules per se. It is all based on existing rules and doesn't actually trigger off some of this yet. So even the Solarwinds indictment isn't necessarily the right precedence either.
Right, because it's pre line in the sand for the regulation to begin. So it's not going to be the case study for this. Really, like you mentioned, the only thing we have is Sarbanes-Oxley to look back on, and how are the first few years of Sarbanes? I'm sure most organizations weren't complying out of the gate when it came to Sarbanes-Oxley, right? And how difficult it was there, but they had better tools to be able to manage. Like you mentioned, COSO for governance, right? They were able to use those best practices. We really don't have that here. So I have a feeling it's going to be a little bit more mucky of a water than Sarbanes was.
Yeah. And then we get to disclosure, right? 4 days to disclose, right? Part of the reason why the SolarWinds indictment comes down is SEC believes they weren't fully disclosing stuff, right? And that it could have had a material impact if it were disclosed to the share price and the shareholders, et cetera, right? So it gets really interesting as the disclosure piece of this I think is going to be more common across the board, maybe, Jason. It's the materiality definition that leads to the disclosure is the other thing. And then to tie this off is, what do I have to do to document this? What do I need from an evidence perspective? I almost have to sit down and have evidence around what I consider material and not material. Then my process of my disclosure and what I disclose and any evidence associated with those decisions also have to be kept somewhere in case you do get an indictment that comes down, because you're going to have to prove that you actually did your job right.
100%. And I almost equate it to dealing with almost like an e-discovery type scenario where you have to have everything well documented. You have to have all the artifacts kept aside and almost have like a chain of custody. I mean, think about it. You don't ever want to be in a position where somebody could challenge the integrity of the evidence that you bring to the table. So there almost has to be a level of chain of custody that you have to manage across this when you're doing the response and the disclosure and providing the evidence. So, there's a whole systemic ecosystem that you have to start working through here to make sure that you're documenting correctly, storing evidence correctly, and have the proper chain of custody across all of that.
Yeah, I think on the front side of this, there's going to be the need to have some type of corporate governance decision, right, and documentation as to what you define as material from a cyber perspective. But post that, the challenge is going to be, and Jason, I'm sure you've been through this, like when you've seen somebody either you know of or yourself that you've been through an incident or a breach, there's a lot of conversation that doesn't go through documented forms, right? For specific reasons, because that information, if it's documented, could be potentially discoverable in a different type of suit, right? And so the challenge is going to be, how do you maintain the decision-making capability and the discussion in that closed format to understand like what is relevant, what isn't relevant, what do you do? And at the same time, you're creating all that necessary documentation that can be used in this type of legal issue if it comes down in the future to essentially assess how those decisions were made, and that materiality decision and then the decision to disclose or not was done correctly. And so those are really competing objectives that are difficult and problematic when you're trying to fix the problem of a breach.
Oh, 100%. And I mean, just in your traditional incident response, there's always conversations with legal about the conversation being held privilege, right? And the question becomes, is in-house legal counsel good enough? Or should you always be bringing in a third party so that way there is that ability to have privileged conversation? Because that's such an important part to decision making is having that privilege, attorney-client privilege to be able to sit there and discuss different legal strategies.
Yeah, I think at least from my own perspective, while there's a lot of decisions whether you get third party advice for the actual breach response, I think the legal perspective, that's almost going to be a given. You're going to have to get third party involved to maintain that separation and make sure that you're getting accurate advice that's relevant, as opposed to your typical core counsel inside of a company that doesn't have experience in this area of law.
Exactly my thought. It's going to be standard to bring in third party.
Yeah, it's probably going to have to be a specialized firm that understands this, because not every firm is going to be able to understand all the nuances of this. So I think you could see an evolution of these very specialized cybersecurity practices within legal entities that are playing that role, because I think it is something that's really interesting, Ben, that you bring up about client privilege, what can get disclosed, what doesn't get disclosed. That's going to be a challenge, and we won't see what the precedent looks like until later.
Yeah, and maybe
that's right. I think you're also going to need potentially there's going to be the need for CISOs to think about individual counsel as well, to make sure that they're making the appropriate decisions to protect themselves. Because corporate lawyers and your third party is to protect the corporation, right? And so you have to make sure that the advice you're getting makes sense to you in your continued role and function. So I think there is going to be a lot of evolving law on this and representation on this as well.
Yeah, it's gonna open up a whole new world for opportunity for services, right? Whether it be the legal side of the aisle, whether it's the platform and the ecosystem to manage the documentation and the artifacts. I just think it's going to open up a whole new service line, for these publicly traded companies when it comes to cybersecurity.
Yeah, it kind of did when we went through Sarbanes-Oxley back in the day, right? It created a whole new series of kind of service lines and capabilities, et cetera. So I think you're right, Jason. We'll see this new service, new technology to track this stuff and document it. It's just a really interesting time because, Ben, to your point, right? Not only do I have internal counsel, I have external counsel for the company, and now I have to probably have my own legal attorney from a personal perspective, because I can't use or necessarily trust the corporate lawyer, because their first job is to protect the company, not necessarily me. So I now have to have my own personal counsel. Oh my gosh, that's just, it's so complex and scary, I think, for some individuals to have to worry about.
This makes everybody want to go out there and become a CISO now, doesn't it?
I actually think it's going to make a lot of there's going to be a segment of CISOs that are going to become lawyers.
Yeah.
Right, because this is going to be a very specialized field, and if you wanted to write your own price, then you have experience in the security side, go be a lawyer.
That's a great point, Ben. Does that push existing data privacy attorneys into a CISO role?
I think so I don't think it pushes people into the CISO role. I think it pushes people out. I've just heard a lot of conversation about CISOs who are senior, who've been doing this for a while, and thinking about, do I really want another CISO role, or do I want to look for an exit opportunity, right? Like, what's my end goal? And so I think the challenge is we've seen a lot of companies in the market recently kind of push down and say, well, maybe I'll just hire a director to take over the CISO responsibility, or, do I really need a high paying person? And I think it's creating this squeeze of, you're going to still have CISOs at a very high level who are making good money, who are leading, large organizations and doing it the right way. You're going to have a lot of inexperienced people who are running the field because there's a lot of void and opportunity being created, but they're not going to have the experience, and it's going to lead to a lot of potential problems. And you're going to have a lot of senior people who are looking to exit and leave and figure out, what do I do now? Because the risk is just too great for the career that I built, and if you get to a certain point in your career and you built wealth, you don't want to lose it because you have to spend it on a lawsuit because you get sued by investors at the SEC.
Yeah, that makes total sense.
Yeah, so that is the exact scenario, Ben, that this corporate CFO laid out for me. They don't have a CISO. It basically has a director of security that rolls to him. He manages all the risks for the business in the CFO seat. He didn't need a CISO. And I think we've already run the stats, right? Less than half of the Fortune 500 has a CISO, but look below that line to the Russell 2000. There's probably 1,500. Well, I know there's more than that. There's probably closer to 3,000 public companies below the Fortune 500 line. How many of those are going to have CISOs? How many of those are just going to have directors, and this is going to roll up to the CFO and change the dynamics of how cyber risks get reported in public organizations?
It's incredibly eye-opening to me right now, the state of the situation we are, because think about the last 5 years, gents, how we sat back and we were having conversations around the seat at the table to influence the CEO, to influence the board. We're going backwards. We're literally stepping backwards.
Yeah. And I think that ties into Ben's point. Like, some of these CISOs who built a really good career trying to figure out whether that's the role they want to do anymore or not.
Right. Yep.
Yeah. So next week, I'm bringing on Patrick O'Reilly. We're going to get into some of this a little more and provide a little deeper dive into things that people can actually do around this topic. I had it set up as kind of a two-part because I wanted to dig into this a little bit. It's such a hot topic right now as we get ready for the new year. So we'll go a little deeper next week into this topic. So with that, we're going to take a quick break, and then we're going to cover the leadership and communications articles for this week.